This is Gibraltar today. The rock is, of course, neighboured geographically by Spain. We're neighbours. There are more than 15,000 cross-frontier workers coming into Gibraltar every day to staff our hospital, our care homes, our restaurants, shops and businesses. But despite this, and perhaps because of politics, there has not been a lot of cooperation on academic studies. So that makes this next conversation extra interesting. An academic paper by a Gibraltar lawyer and a Spanish lawyer focuses on the 2019 Gibraltar-Spain Tax Treaty. It's a collaboration between Grahame Jackson of the law firm Hassans and Manuel Benitez Perez of the University of Cadiz, who both join us now in the Radio Gibraltar studio. Good afternoon, Grahame and Manuel.
Hi, Jonathan.
Hi.
Lovely to have you here. Really sort of got me thinking, this one. You talk about two different legal traditions and how they might be able to interpret one treaty, in this case the tax treaty, but we'll come to another in a moment, how the same treaty can be interpreted differently.
Yes, so there is a thing called the Vienna Convention, which is supposed to iron out some of these problems. But essentially, the fact is that I come from an English Gibraltarian tradition with all the baggage and language that brings, and Manuel comes from a Spanish tradition. And when two people from different traditions look at the same words, they may or may not have different meanings to those people. So we thought it'd be...
Can we get an example of problematic words?
Yeah, we have a lot of examples. For instance, how can you interpret the concept of sporadic absence, which is contained in the treaty? From Grahame's point of view, it's from a UK, a British interpretation. According to your language, you have a meaning for these specific words, but in Spain, sporadic absence has a very specific meaning, specifically in Spanish legal words, so our legal vocabulary. So this is a point of interpretation, a diverse interpretation between both sides. This is just one example.
Overnight, another good example. Yeah.
Overnight
so what
stay.
does overnight mean in Gibraltarian British language, and what does it mean in Spanish legal language? We don't have a definition. There's no definition in the treaty. Yeah. So there's nothing to help us in the treaty. So we just look, what does overnight mean? Well, does it mean until morning? If it means, or does it mean to sleep? If you go to sleep and yet somebody goes to party, is one overnight and one not overnight? How is that? How do we approach that?
Right. So if I went into Spain from 11, as you say, or let's say 9 p.m. for dinner, ended up partying until 6 o'clock in the morning, that might look quite similar on a passport, for example, if there's a timed stamp, just for argument's sake, which there won't be in the case of a treaty, but if you look at a time stamp, that would look quite similar to somebody who might go and have an early night and actually spend the night in a hotel.
Yeah, or even lives there, right? Is that different? Is a party night counted, but is living there not counted and living there counted? So we talk about that in the article, and the whole point of it was to draw out the differences between our different legal traditions, with respect to both legal tradition. But so we took that and we use our starting point. What are the rules of interpretation in Gibraltar, and obviously derived from England, and what are the rules of interpretation in Spain?
Okay, and Manuel, we've spoken to Grahame on the show before, but give us a little bit of insight into your own background. You're based at the University of Cadiz?
Well, I'm a Spanish international tax lawyer. I'm a PhD, specifically focused on tax residency of individuals since the 1st of July of 2022. And this is a very important date because 1st of July is the change of semester of the tax residency for individuals. So this is very interesting. And I'm very focused on that, on working with clients, private clients especially, and also corporate clients on tax residency issues, these kind of things. I'm trying to specialize myself in Gibraltar, in the Campo de Gibraltar area, to give a response on the very different scenarios and very different issues that the taxpayers in general have from a tax residency perspective, because we do have, as we are speaking about, we do have the general rules for tax residency in Spain and in Gibraltar, and afterwards we have a sui generis rules for tax residency, which is very unknown in the international tax context. We can only find a precedent maybe in the Franco-Monaguese treaty on 1963, I can remember, which has just one rule in Article 7 for individuals, but we don't have a whole legal text for exchanging of information and tax residency, not only for individuals but also for companies. And this is my main topic.
From my perspective, I remember when we, as somebody who isn't trained in law, I remember looking at when the tax treaty, the agreement was signed, and then sort of having conversations about it, and it struck us that it wasn't a copy paste from another treaty, another
absolutely not,
treaty.
Absolutely not. That's why this is such an interesting exercise, because there are if they'd copy pasted the OECD model, right, and then it would be a proper double taxation treaty. This is not a double taxation treaty, though it does deal with double taxation. If they'd copy pasted from the OECD, like our UK model does, UK treaty does, then we would not have space to have this conversation, because we would have guidance, commentary, thousands of pages of commentary issued by the OECD that we would be able to follow. Here we don't have that. Spain hasn't issued anything.
We have nothing.
Gibraltar's done some FAQs, but the rules say that you only really look at guidance if it's agreed by the two parties. So
but it's been in force since 2021.
Yeah.
It hasn't been tested. In court.
Be interesting when it does finally.
And we do have only just 2 binding consultations in Spain, which are very obiter dicta, what we call in Latin. So we are not speaking about this specific topic. It was just mentioned in the binding consultation, but very brief, so not important things.
The 2 Spanish things that have been, the binding consultations that have been issued, and ancillary points.
We're talking about an academic paper which has just been published on how to interpret the 2019 Gibraltar-Spain Tax Treaty, and the fact that the Spanish and British legal systems do so differently. So let me ask you this, if I can. You write about this tax treaty being filled with novel language and phrases which are drafted afresh for the purposes of the treaty. If I look ahead then to the other treaty, and one of the things I notice is that the one that we've all been waiting for, the one that's supposed to result in the bringing down of checks for people moving between Spain and Gibraltar, and to make it much more free-flowing. That one has taken a lot longer. The tax treaty was done a lot quicker. Do you have any comment to make in that respect?
So I think that this is a treaty between the UK and Spain, and I think this was drafted bilaterally, mostly by people in Gibraltar, with people from Spain, with some British, UK oversight. The treaty with a capital T and T is going to be an EU-UK treaty.
Exactly.
That's a completely different kettle of fish when it comes to novel language. The EU doesn't generally depart from language that it already understands as much as this does.
And then, therefore, the problems of interpretation that you're discussing
will probably be less.
Should be fewer?
It would be less, maybe in the international field, but maybe in Spain we can have this kind of problems because the EU law and the Spanish law must interact and must be consistent between them. And for instance, regarding the EU law, from the Spanish side, this 2021 agreement must be also interpreted from the for the EU law as well. And in my view, there could be some contradictions with EU law that makes it very interesting, because maybe we can have a rule which is contrary to EU law and therefore null and void.
That's very interesting.
Manuel's filed papers with the EU Commission to challenge the tax treaty. One of the provisions of the tax treaty.
I'm writing.
Interesting. Well, you'll have to come back and tell us what comes of it.
I'll do. When I have a response, positive or negative, I don't know. I hope positive.
Thank you so much for joining us. There's some complicated sort of nuance there, but Grahame and Manuel, you both agree that there needs to be more conversation around
absolutely.
this and
Absolutely.
more academic study.
Cross-border cooperation is absolutely vital to understanding this, and in general, why would we not? Where things are relevant to both of us, why would we not cooperate across borders?
Well, thank you so much for joining us once again, Grahame Jackson of the Gibraltar law firm Hassans and Manuel Benitez Perez of the University of Cadiz.